A landmark school choice case now in the Supreme Court. A few Montana moms are suing to use publicly funded scholarships for private religious schools. Earlier, we spoke to one of those moms and her attorney.
I have been working full-time and then oftentimes working second and third jobs just to keep them there at that school.
This case is about religious freedom, but it's more than that. It's about every parent's ability to pick the best school for their child. The government can't be hostile toward religion. They have to treat religion just like they treat non-religious schools.
Constitutional law expert Horace Cooper is the co-chair of the Project 21 Black Leadership Network, and he joins us now. Good morning to you, Horace. Thanks for being with us.
Good morning.
Good morning. Okay, so you say that the Blaine amendments are bigoted for denying families the best educational options. First of all, what are the Blaine amendments, and why do you think they're bigoted?
Well, a United States Senator, former Speaker of the House of Representatives, even a U.S. Secretary of State, Mr. Blaine introduced this concept into the federal Constitution in the latter part of the 19th century, and his plan was to bar what he said were sectarian schools and organizations from receiving any public support. But what he really meant was, at the time, Catholic churches. That amendment failed in the Congress of the United States, but some 38 states have separately inserted a similar provision. Today, those provisions operate not just to single out the Catholic Church, but actually Christian and religious organizations across the board. They act as an anti-church or faith-based operation in these constitutions. And today, we understand with the adoption of the 14th Amendment, such animus isn't allowed to stand.
How do you think the Supreme Court will rule on this?
Well, if you watched any of the hearings yesterday, what you saw was a significant number, at least 4 justices who spoke, who appeared to be leaning toward giving relief to Ms. Espinosa. And Justice Thomas also has written in an earlier case that he thinks that there's been nothing but bigotry associated with these so-called Blaine amendments.
Well,
At the end of the day, the court is likely to say you can't operate a provision that specifically singles out churches and religious organizations for disfavored treatment.
She makes a good case. She said she's a single mom. She has 2 little girls. She needs the scholarship money to keep her kids in their private Christian school, and that's very important to her. So if the state's going to give her money, shouldn't a parent be able to choose where they want their child to go?
Well, absolutely. And here's the thing. The only reason that they're not doing this is because of her faith.
Correct.
You couldn't operate a highway contract for construction and have a policy that you're not going to hire women. You can't do that. That's unlawful. And then you can't then say, well, if women complain about it, we're just going to stop giving construction money to anyone. It's unlawful behavior, and I believe the Supreme Court is very, very likely to say to Montana and to the rest of the country, you can't disfavor religious people just because of their faith.
That's right. Thank you so much, Horace, for being with us. Keep up the fight.
Thank you.
You're welcome.